Okay, a few examples in practice of where things have gone wrong. The first is a case of a company called Media Logistics, who were sued by a Mr. Roberts, who was a businessman who they sent some marketing emails to. He had no idea what they were, where they'd got his information from. He tracked down who they were and said to them, "Don't like the fact that you've sent me marketing emails. Who are you? How did you get my information? And please apologise." They wrote back and said, "We're Media Logistics, we're very sorry, but we're not telling you where we got your information from," which he didn't like, so he sued them. And the judge said, "Yes, you should have told him where you got his information from. He wins, you have to pay him compensation," and he won the princely sum of £270. Tough stuff. Absolutely. Yeah, it doesn't. The case doesn't refer. He was a businessman. It doesn't say what he actually did, but not a lot at the sound of it. Even quite.
270 a day is all right.
maybe he may well have made a living out of receiving spam emails. It must possibly. The Transcom case actually is very similar, although big money involved here. This was a Mr. Dick who sued Transcom. I make no comment. This again, Transcom had obtained his details from a mailing list, but they didn't check. They bought the list in from somebody else. They didn't check that he'd actually consented to receiving marketing emails. He hadn't, so he said, "You shouldn't have sent that to me." He sued them, and the court said, "That's right. You shouldn't have sent him that email. Mr. Dick, you get £750.
Ooh, we're getting there.
Going up. It's getting good. Transcom, yes, when they bought the list, they may well have done it. They may well actually have got an indemnity from the person that they bought the list from, because they could then they would then be stuck with having to face Mr. Dick in court, because ultimately they're the person that sent him the spam.
Does it cost more than £750 to change your name?
No, I don't think so. Question for the family department. I don't think it does. Yes, in that situation, if they'd gotten it secured indemnity, then as soon as the judgment is delivered, they have to pay them £750. They can then turn around to the person they bought the list from and say, "This judgment for £750 has been made against us. It's your fault. You've given us indemnity. Pay us £750," and then they can sue that person.
So technically, they're going to have to sue them.
Yeah, unless
they fund it.
Exactly, unless they just pay up. Now, both of those, obviously, we've had a lot. Both of those are very low value. The reason for that is that compensation in law for these type of cases is based on what loss have you suffered, and what loss have you suffered as a result of receiving an email you didn't want. Exactly.
Now earning £750.
Correct. So, yeah, I mean, ultimately they hadn't suffered any loss at all. I suspect the reason they were given compensation was the judge was desperately trying to find a way of disapproving of the fact that they'd received the emails. The more significant case, not surprisingly involving Microsoft, is Microsoft and McDonald. Now, this case was actually in the papers a few years ago. Mr. McDonald was a chap who collected email addresses. Kind of turned his hobby for some strange hobby, turned it into a business. He collected huge lists of email addresses, then he sold them to as I have in my notes, to spammers, to people who just sent lots of marketing emails and junk emails, indeed, about not very much. And he made a living out of flogging these email addresses. And Microsoft sued him for reasons that I'll come to in a moment. So those are the two. Obviously, people traditionally used opt-outs. This comes back to the rule I talked about earlier, where silence generally isn't consent. You're wanting people to do something. So the European regs, again, where this comes from, are all saying, I don't really like opt-outs, because an opt-out is you're not physically doing anything to opt out. You might just have ignored it or not seen it. So what do you actually need consent for? If you're going to do marketing, you need consent to market your own stuff, other people's stuff, or if you're going to transfer the data to somebody else. All of those you will need consent to market. Now, the current position in law is that you must obtain an opt-in style consent or similar. Now, theoretically, an opt-out shouldn't work anymore, which is the point we just discussed. And again, it comes back to the law wanting your customer to have actually positively done something to say, yes, I'm happy to receive this email, and not just ignored it. So I've said they're active steps to demonstrate that they're happy. Tick box, click icons, something where they've actually had to subscribe, so they've actually had to send something back to you, all of those kind of things. The idea, all of this is pushing towards not being able to send marketing emails to people who just didn't read the small print, coming back to your point. But having said that, I do still see opt-outs all the time. Indeed, as lawyers, we're required to go on a certain number of courses per year to make sure we're up to date with the current law, and one of our major providers, who shall remain nameless for these purposes, has a form at the end of their courses that you go on whereby you have to sort of rate them out of 10 and say whether the course was any good. And in the small print at the bottom, there's a little bit that says, we are going to send you marketing emails if you don't want us to do this tick here, which is an opt-out, and they can't do it. And I told them this. And they said, oh yes, we're changing the form. And I went on the next course a few months later and they hadn't changed the form. So you still see it, it's wrong. It's one of those, until people complain about it, probably stays wrong, frankly. But of course, you should all do it right. Okay. As ever, there is an exception where you can still, in theory, use an opt-out. And as lawyers, we like to confuse people, so we've decided to call it, this is not me, this is sort of nationally, this is what it's called, the soft opt-in, which is an opt-out. Yes, exactly.